Hi, Bill Cottrell here. Welcome to Law Talk. Today I've got with me Andy Green, an attorney from Cottrell Law Firm, and we'll be talking about collecting debts. My name is Bill Cottrell, and I've been practicing law for 34 years. With me, Andy, good afternoon.
Good afternoon.
Andy, let's get right into it. With respect to debt collection, what's normally the first thing that a law firm will do when they're trying to collect a debt?
Well, after they reviewed all the documentation, determine if it's a consumer or a business debt, then either you would send an initial demand letter to the debtor, or you could even proceed right to starting a lawsuit if it's a business debt.
What type of various fees could a lawyer charge when they're hired to collect a debt?
That's a good question. Typically, law firms will charge like an hourly fee for any work that's done on the file, regardless of the outcome. You can do a flat fee where the client would just pay a base fee, and it wouldn't increase or get lower. It'd be that same fee. And then there's also contingency fees, which is pretty common with collections, and that would be where the law firm just gets a percentage of whatever they collect on behalf of the client.
Let's say, for example, that that demand letter gets sent and you get no response, and that neither through phone calls or letters will the person owing the money respond to you. Will you then start a lawsuit typically?
Typically, yes. If you have the client's consent and they want you to start a lawsuit, that'd be the next logical move.
And explain what a lawsuit is in Minnesota and how it gets started in district court.
So a lawsuit in Minnesota gets started just by serving what's called a summons and complaint upon the debtor or the defendant. And that's just somebody handing them the pieces of paper. It doesn't necessarily mean that anything's been filed with the court yet.
And the person who serves it, do they have to be a sheriff or deputy, or can they be anyone over 18?
It's just anyone over 18 as long as they're not a party to the action. So you can't, if you're the plaintiff suing, you can't be the one actually serving the paper.
And you can hand that summons and complaint to the defendant or the defendant's spouse or somebody in that household that is of suitable age and discretion, and if they don't respond to that summons and complaint, and if the attorney has put in the lawsuit that they're suing on a contract or on a stated account, isn't it possible, isn't it true that a default judgment could be obtained without ever having to go to court?
Yes.
How is that possible? I would think everyone has a right to their day in court.
Well, if you don't if you don't come forward and assert your rights prior to the expiration, so that when you get the summons and complaint, there's lots of notices on there that you only have a limited amount of time, 20 days, to respond to the allegations in that lawsuit. If you just don't do anything, ignore it, it's not going to go away. The attorney or whoever is suing you can go to court and get a judgment against you by signing an affidavit basically saying that the debtor didn't respond.
And they actually wouldn't even have to physically go to court. They could do this through the mail.
Right.
I believe there's a filing fee of somewhere around $350 for district court.
Depending on what county you're in, it can range from $320 to $332, I believe.
And then once that administrative judgment is obtained by the plaintiff, what can the attorney do in order to collect it? It's now been reduced to what's called a judgment. Is that what you generally need in order to start the forcible collection action?
Generally, yes. I mean, if the debtor doesn't respond, there's ways that they can start wage garnishments and bank levies prior to actually filing anything with the court, but it's pretty common that a creditor would wait until they get a judgment before doing that.
So the attorney has the legal right under state law to garnish wages. What percentage of their wages in general do they get?
It is 25% of take home.
And
pay.
and what about if they were able to find somebody's bank account and there's no exemption or objection claimed? What would the creditor get if they levied on somebody's bank account?
The creditor would get anything in that bank account less whatever claims the bank might have against the debtor.
Could the law firm use the sheriff and seize things like vehicles, pets, watches? What kind of things could the attorney have seized from the judgment debtor, from the person that they obtained the judgment against?
Everything you just listed could be seized by the sheriff. There are some exceptions to that. You had mentioned exemptions earlier, basically.
Go ahead. Tell us about what is an exemption,
Right.
and how do you assert it?
Sure. So an exemption is just basically a value of property or some type of property where the state says a creditor cannot take that money or property from you. So
The state of Minnesota has laws, in other words, that exempts a lot of assets.
Right.
What's the homestead exemption in Minnesota?
in Minnesota, it's $390,000 for a homestead, and I believe it's almost $900,000 if it's a homestead that's actually a farm as well.
So just to be clear, a person could have equity in their homestead, and creditors other than a mortgage or lien holder can't touch that. Is that
Right.
right? How about for an automobile? What kind of exemption can you have for an automobile so people don't take your means of transportation?
I believe it's $4,600, but on top of that, you also got to consider that the creditor would have to have the sheriff take and seize that vehicle and then hold an auction to sell the vehicle, and the sheriff would get to take whatever fees they charge for seizing the vehicle and for holding that auction from the top of whatever they recovered from the vehicle, and then also the debtor would get the $4,600. So if it's a pretty old car, it's probably not going to make sense for a creditor to go through all that trouble.
Now, I've been doing this for over 30 years, and I've got a couple stories for you related to sheriff seizures. We don't do them very often, but every now and then you can do quite well. I obtained a judgment for about $30,000 against a guy who didn't pay one of his employees, and she knew that he had an art collection and a glass collection. So we arranged to have the sheriff enter his home with a court order, and the sheriff actually seized the art collection and the glass collection. They held an auction. There was enough interest in the art and glass that eventually we were able to collect the entire judgment through that sheriff levy.
How long was that? How long did that take, that whole process, from having the sheriff go out there to actually doing the sale?
Well, they do have to publish a sheriff's notice in the county, and that's a notice to the public, and then people can show up at the sheriff's sale and they can actually bid on the property. I don't know exactly how long it would take, but from the time the sheriff seized the assets, I'd say about 3 months later we had it pretty much wrapped up. Well, let's move on. We've talked about exemptions, judgments, how to collect debt. What kind of protections are afforded consumers who get harassed by debt collectors, whether they be lawyers or collectors?
Well, right away the federal laws come to mind that prevent debt collectors from engaging in any abusive or deceptive, misleading acts as far as their efforts to collect against debtors. For one thing, they can't use any misleading statements. They can't claim that you owe $1 million when really you only owe $1,000. That's a pretty extreme example. But there's also laws regarding phone calls. I know they can't. There's a lot of limits on what they can use as far as telecommunications go as well.
Well, you can't harass the person. You can't threaten them with a lawsuit if you know that there's no intent to file or even proceed with a lawsuit. And under the Fair Debt Collection Practices Act, which I know is a mouthful, the attorney or collector can actually get penalties of up to $1,000 plus attorney fees. So there's a tremendous risk if an attorney or debt collector violated that federal law. Is that right?
That is right, and if they engage in a whole lot of the behavior that violated the Fair Debt Collection Act, there can also be class actions brought against them with potentially more damages than the $1,000.
Well, let's get back to this court process of obtaining a judgment. We talked about how to get a default judgment. What happens if the defendant, either pro se or through an attorney, puts in what's called an answer, where they serve an answer where they actually dispute owing the money? How does that end up getting before the court?
So if the defendant or the debtor or the defendant or debtor's attorney serves an answer where they're responding to the allegations in that lawsuit that the defendant was served, then the plaintiff's attorney would actually have to go to court and affirmatively seek the relief that was being sought in that lawsuit, as opposed to earlier where they wouldn't even have to go to court. They could just send in the lawsuit and get the judgment entered administratively.
So it could eventually go to a court or jury trial, or the case could get resolved through what's commonly called a summary judgment motion. Why don't you tell our listeners what a summary judgment is, so that they realize that it's possible the case could be resolved without ever having a trial?
So summary judgment is, it's kind of, so it's basically saying that there are no facts in dispute and that the judge presiding at the hearing can rule as a matter of law as to the allegations and the affirmative defenses that were raised. But that's not always like the easiest thing to understand. Basically, if the defendant's not saying that the facts aren't true in the complaint, then the judge can just say, all right, well, I'm just going to rule as a matter of law on the claims of the plaintiff.
So we got this summary judgment motion, and you're saying that it's not a sure win.
No.
Let's say that the defendant or debtor survives the summary judgment. Maybe they file an affidavit setting forth that there's some factual issues in dispute. What happens next? Do they end up in mediation? Do they end up going to trial? Is it a jury trial? How does this all work?
It depends on a lot of factors. So if the judge denies the motion for summary judgment, then a lot of things could happen. One of them that's very common nowadays, which I know wasn't that common, you probably have more experience than I do, is
I'm older.
yeah. But mediation, I think you mentioned it, and that includes both alternative dispute resolution and just, I guess, mediation. Those are...
What could be arbitration?
Right, arbitration, you're right. So arbitration, you'd actually go in front of an arbitrator that would act a lot like a judge and a jury, and they would hear each side's case and then make a decision on it.
And there'd probably be a large fee involved, right, typically?
Yeah, I don't know. I'm not very familiar with the different fees, but yeah, probably. And then the parties would make an agreement that they would consider whatever decision the arbitrator makes binding.
Got it. All right, well, one thing we want to talk about is the difference between conciliation court and district court. There's, in our law practice, we almost use district court exclusively, but a lot of people want to use conciliation court. Why don't you tell the listeners what the advantages are of conciliation court?
One of the main advantages is it's much cheaper. I believe the base fee at most counties is $75, and it can change a little bit up to in the 80s, but that's a lot cheaper than district court, which, as I said earlier, is about $330, $300.
Okay. And then with conciliation court, you don't have to follow all these procedural rules that a judge might order in district court. You can basically just obtain a hearing date, show up for the hearing date, present your testimony, and especially if you don't have an attorney, I think the claim amount is somewhere around $15,000, isn't it?
That's correct.
And so you could actually bring a lawsuit against a business or a neighbor or somebody you have a dispute with and try and get a judgment in conciliation court without even hiring a lawyer.
Right.
Now, what are some of the drawbacks to conciliation court? Why would somebody maybe not want to even try conciliation court?
Well, one of the main things is if you are having an attorney appear on your behalf, not only would you be paying for them to prepare the claim for the conciliation court, but you'd also have to pay them to go appear at the hearing. Whereas with district court, if the debtor doesn't interpose or serve an answer or a response to the complaint, then you wouldn't be paying for any court time because that attorney could just file administratively for default judgment.
Andy, we're going to take a short break and then we'll come back to that subject. Thanks.
Okay, thanks.
Of all the things you've done with your bike, donating it to Goodwill may be the most incredible of all. Your donations help fund job placement and training for people in your community, which means your stuff can be more powerful than you think. Goodwill. Donate stuff, create jobs.
I guess sometimes things just happen. Devastating things. Your whole world changes in an instant. That's what happened to me the day my mother had a stroke. I'm Paul George, and I want you to spot a stroke fast. F, face drooping. A, arm weakness. S, speech difficulty. T, time to call 911. Protect the ones you love. Spot a stroke fast.
Welcome back. We're back with Andy Green. We're talking about collection of debt, and we're on Law Talk. Andy, we were talking off the air about conciliation court, and one thing I want to advise the listeners is that sometimes conciliation court can have disadvantages. One of the disadvantages is that either side, if they're unhappy with the results, can quite easily, by just filling out a simple form and filing it, then they get to have their day in the next court, district court. So you could spend 2-3 hours in conciliation court. You could think you won, and yet the other side could just pay a small filing fee and be right back into district court. In addition, for an attorney who's charging a lot of money per hour, the client might be disappointed in hiring an attorney and then paying a lot of money for the attorney to go to conciliation court and then finding out that they have to start all over again in district court. Would you agree with that?
Right. Yeah, and you get to argue everything over again. Right.
It's a trial de novo. And then we were talking again off the air about a deficiency judgment, and I think people need to understand that even after a car is repossessed or even after a home is foreclosed upon, there can be times, not always, but there can be times when a creditor can go after someone for a deficiency. Can you explain how that might work?
A deficiency is what still remains on the amount that you owed after the foreclosure or the seizure of whatever secured property, be it a home or probably like a car.
Let's use I think a car is an excellent example because a lot of people finance their cars through various banks and loan acceptance companies. Let's say they can't keep up on their payments and the car gets repossessed. What happens next?
Then after it's repossessed, the creditor can go and start a lawsuit like we were talking about earlier against the debtor for the remaining balance after crediting them for the value of the car and if they resold it, what they got for it.
So if somebody owed $10,000 on a car and when they sold it at the auction after repossessing it, if they only recovered $6,000, excuse me, then there'd be a deficiency that they could sue you for. Is that right?
Right.
All right. And then what kind of debts do you see attorneys trying to collect? What's some of the typical debts that you'll see?
Credit cards, student loans, second mortgages, promissory notes of whatever kind, like professional fees. Sometimes lawyers sue their clients that don't pay them.
And let's say somebody's facing a staggering amount of debts and they get these judgments against them and they can't afford to have their wages garnished. What can somebody do?
The first thing you should do is talk to a lawyer, but what that lawyer would do is look at what kind of income you have, if you're receiving any benefits from the county, because that could entitle you to exemptions. If you're not getting those sorts of things and you don't have a lot of assets, bankruptcy is another option that you could explore.
So can pretty much anyone who's got a lot of debt file a bankruptcy, or are certain people excluded?
Certain people are excluded, I believe, yes.
Well, I think you can only file a Chapter 7. There's about three kinds of bankruptcies. There's a Chapter 7, there's a Chapter 13, and there's a Chapter 11. A Chapter 7 is when you just get all your debts pretty much wiped out, except for things like student loans, taxes, and debts where there's collateral. You're not able. You still have to pay back your car loan or your mortgage. You don't get out of those debts by filing bankruptcy. But a Chapter 13 is a wage earners plan. That's where somebody, as you point out, has a certain level of income where they can't file a Chapter 7 bankruptcy. And so then they'll file a bankruptcy, but it's called a Chapter 13, and they will pay to the trustee in bankruptcy a certain amount each month, and then that money will then get distributed to their creditors. That's beyond the scope of this show. We'll have a special show just on bankruptcy. So let's get back to talking about collection of debt. Does a judge or jury here, if it goes to this, if there were a trial, would a judge or a jury handle a debt collection case?
It depends. The plaintiff, who's typically the creditor, lots of times will waive the jury trial just because it's going to add a lot of time to the trial. And a lot of times the defendant or the debtor will agree to that and just have the case heard before just a judge. But as a debtor, as a party to the action, you can always request that the trial be before a jury.
We're in Dakota County, and if I were to start a lawsuit tomorrow, and if it ended up going all the way to trial, typically when could I expect a trial? In 3 months? In a year? What are you seeing?
It depends on the amount of the debt. If it's very high, like over $20,000, it could be 9 months, a year, depending on what kind of stuff happens. And if it's very contested, it could go longer than that. But typically in Dakota County, if it's under $20,000, it's just a basic consumer debt. I think the trial's in like 3 to 6 months.
And could somebody who's a corporation, maybe a small business such as an LLC or a 3-person small business, could they represent themselves in these disputes?
No, you'd need to hire an attorney.
You're absolutely right. Even if you're a corporation, or even if you're a one-person corporation, the laws in Minnesota are very clear. You can't represent a company unless you're an attorney. I don't see any way of getting around that, do you?
No.
Now tell us a little bit about a power of attorney, though. That's something that you often see for elderly people, but I would have the right to give power of attorney to somebody else to handle my business and legal affairs, couldn't I?
Right.
Tell us a little bit about that. Just explain it to our listeners.
The power of attorney is where you explain it pretty good, that you just give another person legal rights to make decisions for you that are binding.
All right, yeah, so it's a legal form, has to be correctly filled out, has to be signed, possibly notarized, and then that legal document is then used to show that the other person has the right to act on behalf of someone else, right?
Right.
Andy, what are some of the things you think, with respect to collecting debts, what do you find interesting?
Well, we talked about already, but the exemptions are pretty interesting to me, and how you can use that as kind of like a strategy of how you want to go about the case. For instance, if a creditor approaches you and they say they have maybe a $10,000 debt and they want to go collect it, but then they start explaining to you the financial situation of the debtor, you could take a lot of the information you have about those exemptions and use that in giving the debt collector advice, or not the debt collector, but your client advice about whether or not they should actually spend the money and the trouble going about hiring you to collect the debt. For instance, if the debtor is receiving assistance from the county, so in Minnesota it'd be medical assistance or food support, which are both very common, then you would be unable to garnish any of their earnings while they were still receiving those benefits, which makes sense if you think about it. Why would the state allow a creditor to take money from a person that the state has determined that they don't have enough money to pay for their own food or medical assistance?
Can you work out some type of a payment arrangement once you've been sued? And how do you work that out with the attorney or the law firm that's handling the case?
That's a good question. That's the first thing, if you have the ability to do, that's the first thing I would recommend anybody doing if they're facing the possibility of being sued for a debt. Because in reality, that's all the person suing you really wants, is just some money. And a lot of times the debt collector and their client are willing to accept some pretty reasonable payment arrangements that are much less than the amount you actually owe.
I think it's called a stipulation and confession of judgment. That's what we use, and it establishes an agreement on the amount owed, the monthly payment that's required, and as long as the payments come in on the agreed upon dates, you can avoid getting a judgment. However, if you miss any payments, oftentimes that'll trigger a default, and then you could easily end up with a judgment. Now, a judgment affects you in more ways than just giving the creditor the right to go after your bank account or garnish your wages. It also affects your credit report, as does the fact if you default on credit cards or you default on payments, the credit bureaus are going to get a hold of that information, and then you're going to have a major effect on your credit report, which is going to affect your ability to get car loans, home loans, and even apply for routine credit cards.
Right.
What is it about collecting debts that drew you into that area of the law? It's something you were interested in for a long time.
Right. Well, the whole you mentioned earlier with debts that have collateral, that was really interesting to me. So if you have a car loan and what creditors, what kind of rights they have in that actual collateral. So in that instance, the actual vehicle. A lot of people don't know this, but sometimes when you get credit cards to those department stores, you actually, in the terms and conditions of the credit card agreement, you give them a security interest and everything you purchase at the store with that credit card, which, I mean, if you think about it, what creditor is really going to spend the money to have a sheriff go through somebody's stuff to find like a laptop or something? That
They're not going to repossess a
Right.
refrigerator.
Right.
Well, Andy, it was a pleasure having you on the show, and I look forward to working with you in the future. And I know we tried to cover a large area of the law in a matter of about 25 minutes, so thanks for bringing your expertise to this show.
My pleasure. Thanks for having me.
Thanks, Andy.